Matters of the law now, and a father will now be able to register his child in his name, whether or not he is married to the mother. The Constitutional Court has ruled that Section 10 of the Births and Deaths Registration Act is unconstitutional. It says there's no reason to differentiate between married and unmarried fathers. For more, we are joined now by Thandeka Chauke from Lawyers for Human Rights to unpack all of this. So, Thandeka, it would seem to me that over the years and through various instances of litigation, we're slowly carving away at these discriminations, particularly in as far as the issue of parents who are married and those who are not married to each other, and what that means for their children and the various administrative processes that attend to that. Just from a broad perspective, of what benefit is this ruling?
It's of great benefit to the children who have struggled to have their births registered because they're in the care of unmarried fathers. Birth registration has a direct impact on the ability of a child to have a successful and meaningful life. And a birth certificate might seem like an unimportant piece of paper, but it's a very critical document that allows children to have access to the very basic human rights. For example, the ability to go to school, to see a doctor, to access social assistance, but also importantly, it gives the child a sense of identity and a sense of belonging. So it's a very important judgment, and it will go far in terms of not only guaranteeing the rights of children, but also ensuring that they will have a better life.
So we'll get in a moment to how this judgment impacts, children born of foreign nationals who are in South Africa, whether documented or not documented, because I understand that to be a particular area of interest of yours. But before we get to that, give me some examples then of fathers that would have been disadvantaged by this, or the children, to be more accurate, who would have been disadvantaged. Because my understanding is that until now, the father would have needed the consent of the mother to be able to have the child registered in their father's surname if they are not married to each other. But there are instances where the mother is simply not there.
Yes, so this particular provision of the Birth and Deaths Registration Act states that for children that are born to unmarried parents, for them to be registered in the surname of the father, it requires the involvement of the mother. So in practical terms, how it plays out is that the mother might not be able to participate in the registration process, where, for example, she is deceased, she has absconded or abandoned the child, her location is unknown, and even where the mother herself is undocumented, it's presented to be an issue for the father to document the child. So what the court has done is, in their ruling, they've not only declared it unconstitutional, but confirmed that it constitutes unfair discrimination on the basis of marital status, on the basis of sex and gender. So it not only impairs the dignity of the unmarried fathers themselves who wish to play an active role in the lives of their children, but also of the children who are then, subjected to this unjustifiable differential treatment to children who are born to married parents.
So then let's go to the issue of how this has until now impacted, the children born of one parent at least who's non-South African and in some instances not documented, because the origins of the case come from a case that had occurred in the Eastern Cape, where Home Affairs simply refused to have a child registered who was born of a South African father and a Congolese mother who had been married in the Congo in terms of customary marriages there, but the marriage was not recognized in South Africa, and that's where this difficulty arose. They got relief from the court, that particular couple, but the problem persisted. To what extent has this hurdle rendered some children stateless?
So this continues to be one of the main barriers to birth registration and accessing nationality for children who are born in South Africa. When the case originated in the Makanda High Court, the initial judgment, in fact, ruled against the regulations that state that parents have to provide valid documentation for the registration of their children. And the court said that the department needs to interpret that provision widely and constitutionally to say that the documentation should only be provided where it is available, so that the children don't go unregistered and then face the risk of statelessness. And of course, it has big implications for the child, where the need for registration has a direct link to them being able to access citizenship, either in the country that they're born in, so either in South Africa or their other parents' country of nationality, which in this case would have been the DRC. So they would have needed the South African birth certificate to claim citizenship in South Africa or the DRC.
Sure. And this is something that happens a lot, is it not, Thandeka? Given the situation we have with migration patterns in South Africa, and accepting the reality that there are many parents, there are many people who are in the country, either documented or undocumented, who end up in relationships with South African citizens, and out of those relationships, children are born and they are left in limbo.
Yes, it is a cause of concern, and as I've mentioned before, one of the main causes of statelessness. And I think why birth registration is something to pay particular attention to is because lack of birth registration or leaving children going unregistered is something that is quite preventable, and something that will go a long way in terms of us creating generations of people who are undocumented, or generations of stateless people.
Lastly then, Thandeka, just your broad sense of the extent to which this judgment clarifies areas of rights and responsibilities between parents, married or unmarried, the extent to which it should facilitate the other rights, access to the other rights and responsibilities that a person can have towards a child.
The judgment reaffirms the fact that there is an equal responsibility on both mothers and fathers to ensure the registration of their children, but it also creates that room for unmarried fathers or single fathers to be able to play a more active role in the lives of their children, without barriers that are presented by not appearing on the birth certificate and being acknowledged in law as the parent of the child. So it's also in line with what has been said by other international bodies, such as the Committee on the Rights and Welfare of the Child and the African Committee of Experts on the Rights and Welfare of the Child, in terms of ensuring that parents have a joint responsibility to register their children and to ensure the protection of their children.
All right, I've got to thank you for your insights. That's Thandeka Chauke from Lawyers for Human Rights there, talking to us about the judgment that came out from the Constitutional Court. One way of looking at it would be to say that it's a victory for unmarried fathers of children, but I believe a more accurate way of looking at it is that it's a victory for the rights of the child, who should never be disadvantaged simply because, they happened to be born of parents who were not married to each other. It was an anomaly that has now been sorted out by the Constitutional Court in a country where the rights of the best interests of the child are of paramount importance in any matter involving a child.